let's talk about that. After several decades, have we sustained the movement? How does the current work of community paralegals, public interest lawyers, human rights lawyers, legal empowerment organizations look like in the present times?
I would like to summarize the current state in actually two words. One is that it has expanded, and then second, it has also matured. What are the kind of indicators that it has expanded? Well, paralegal movements have now branched out into many areas. Typically in the beginning, you would have the basic sectors, like farmers, the fisher folk, the women, especially rural women, the indigenous communities. These are very, very important sectors. But now we are now seeing that paralegal movements have branched out into many other applications of the law. For example, there are now groups that focus only on the rights of lesbians and gays and the transgenders. There are groups that focus only on the rights of detention prisoners. You see, expanded to the protection of coastal communities. We now have this huge phenomenon where volunteers, fishermen in the coastal communities, use actually their own time and effort, and sometimes with the support of local government, to protect their communities, their coastal waters from the poachers, from the illegal fishers. And this is another type of paralegal movement in a sense, combined with action, because once you're able to catch somebody who is fishing illegally, there are also protocols on how to mark and preserve the evidence. Those are some of the indicators of expansion. One of the indicators of maturity is that at the moment, even now, the Supreme Court has taken cognizance of the role of civil society organizations and paralegal movements doing legal empowerment work. Why so? Before you are able to graduate fully as a law student, you are required to undergo several hours of work with legal aid organizations. And the Supreme Court has come out with a rule that aside from working with law firms, working with government institutions like the courts or the prosecutors, you can also work with legal empowerment organizations. And in their guidelines, they have adopted the language of legal empowerment organizations like legal education, human rights awareness, advocacy. So here we have a situation where in order to graduate from law school, you could actually work with a legal empowerment organization. And this is a mandate of the Supreme Court. So therefore, I would argue that legal empowerment work has now matured to such a state where even the highest court of the land has included among the various ways of doing legal aid, you can do it with a legal empowerment organization. And this is a very welcome development because now the state has recognized the work of all of these organizations, especially in protecting the rights of the vulnerable and the marginalized. So this is, to me, a indicator of the maturity that we have achieved in legal empowerment work in this day and age.
Thank you, Hector. Expansion and maturity as far as the Philippine experience is concerned. How about South Africa?
I'm so envious. I'm very, very envious of our comrades in the Philippines because I would use the word of, like one word that comes to mind is stunted. It's stunted because of the many struggles of the sector post democracy, post adoption of the constitution. There is intention. There's beautiful intention, in fact, from our mostly political leaders to recognize, and they know the value of the work of advice office. It's not translating into law at this point in time. We went into a process where the legal practice, it was first a bill and then it became an act. And the only provision that's there in that act is that there should be an investigation by the Legal Practice Council on what model the Minister of Justice must adopt in regulating paralegals. And you would imagine that that is an investigation that was supposed to commence in 2018. We believe that the report has been finalized, but it hasn't. It's yet to be brought forward for the sector to engage with it. It's yet to be at the stage where the minister then issues regulations, because our understanding is that that should then result in regulations that are governing or that are attached to the Legal Practice Act. And so it has really been a frustrating process for the sector, because you get to a point where explaining your existence is almost, it undermines the efforts and the role that advice officers have played to get the country where it is in terms of its own constitutional dispensation. And it's stunting the growth and the ability and the potential of the sector. I mean, one of the ways that we have presented to the Minister of Justice is exactly what the Philippines is doing, to say that actually advice officers are centers of learning. If you really want to transform the legal profession so that it does not, or is not seen to be servicing only the elite in the country, then you need to give young upcoming lawyers or young upcoming legal practitioners a glimpse into what a majority of the population is living in and what kind of legal services they actually need. Otherwise, you will continue having a situation where a lot of legal practitioners are unable to service low-income communities. They are unable to even relate, even from a legal point of view, with communities, marginalized communities who have very particular legal needs. And working with an advice office, you can actually build that capacity for legal professionals to then be able to provide legal services that are in context with the needs of these communities. And so, that has been a process. And so the sector in South Africa is really finding itself at that point where it's still in that struggle. It's still in that struggle for space and recognition, and to really be taken on as, we say that, the justice system in this country is an ecosystem that is involving many role players. You take out one part of this ecosystem, then the system fails. And our argument is that advice officers continue being the access point, continue being even the point of implementation, because it's wonderful getting a constitutional court judgment, but it's still, that judgment still needs to go back into a community and still needs to be actioned. There still needs to be a model of accountability. There still needs to be a model of measuring how effective is this judgment that the Constitutional Court has given in relation to addressing the legal issues that came from these very same communities. We're talking about grants, about social protection mechanisms where the court has made pronouncements to say that it cannot happen in this way, it needs to happen in another way. That still needs to happen at a community. It doesn't happen only in court. The court is only there to give a framework of what is within the constitutional jurisprudence, but ultimately implementation still needs to happen at a community level. And so the advice office is instrumental in bringing the case to court, but it's also instrumental in making sure that what the court pronounces also gets implemented at a community level. So our role is not only at the inception stage, but it's also at the implementation stage, and it's also at the measuring stage to see how effective is this process of taking matters to court and then getting a favorable judgment, and how favorable is the judgment actually from a practical point of view. And so, yeah, that's the unfortunate word that I can use, but we are, I get encouraged when I hear and I learn of how comrades in other countries, in other jurisdictions are forging ahead, and they're just keeping at it. And it's wonderful that we have a model to also look into when we engage with our government, to say, but look at how the Philippines has done it, and this is how it's actually impacting on legal empowerment at a community level. Because that's we want to say, keep the spotlight on the community. Make your processes community-centered, make your processes community-led, and that would mean that your processes ultimately derive community impact. They become impactful at that level. Thanks, Marlon.
Thank you, Chenola. And it's really a continuing advocacy for grassroots justice advocates. Final question for the two of you. What is your message for grassroots justice advocates from different countries? Chenola first.
What is the message? You know, I want to encourage justice advocates that sometimes you can only help one person. And sometimes the problem looks bigger than you. But when you impact the one person, you impact a household, that impacts a community, that impacts a region, that impacts a country, and ultimately that impacts the world. So we must never underestimate the efforts that we you know, the different ways that we're working. And if we keep our focus on empowering, even if it's one community or even if it's one individual, that is having a ripple effect. What the Philippines is doing is having an impact on what South Africa can look up to, and the potential that we can work towards. And so really the work of paralegals, as much as it might be, you might think that you're working, it's in your community and it's only you. That is not the case. That one case that you've resolved, that one mediation that you've managed to prevent an outright conflict within a family has a bigger impact than what you can imagine. So just keep at it.
Thank you. Hector.
Yeah, my message is quite similar. That in fact, I'd like to put it more emphatically to say that we should not lose hope. You know, I have seen the transformation of my country from the 70s to now. I have been, I campaigned for the 1987 Constitution. We set up alternative law groups in the 80s and in the 90s. I work with the Supreme Court now, and I've seen how the work at the grassroots level has impacted on the thinking of even the chief magistrate. And I think at the core really of the work is that, you know, we let's forget the dirty word sometimes called human rights, because sometimes people, you know, especially the politicians, make it a dirty word, you know, like it's communist, etc. Let's just use the word human dignity, because essentially that is, human rights is all about human dignity. And I think if we keep on harping that protecting the rights of women, the rights of prisoners, the rights of farmers, the rights of the lesbians and the gays will promote human dignity, I think people will listen at the end of the day. Who can argue against human dignity? Nobody will argue against, people will argue against human rights because it sometimes has a bad name, but you cannot argue against human dignity. But to me, they're the same. I mean, they're essentially the same. So I think we should just keep on pushing. And I think eventually people will listen, because human dignity is the very core of our existence. And that, to me, is where we should kind of anchor our argumentation. And if we do that, I think people will listen from the high to the middle and to the low. Thank you.
Thank you, Hector. And on that note, we end this conversation. But let me just say that the presence of Chenolo and Hector shows us that the struggle continues. It evolves, the movement continues to experience challenges, but we are still here. It's very much alive. Challenges may also evolve, and we adapt to different issues. We adapt our respective programs, but the struggle continues, and there is hope that we see. Thank you very much for this very interesting conversation about history of legal empowerment. Thank you, Chenono, and thank you, Hector.
Thank you,
Thank
Marlon.
you.
Thank you.
Thank you very much. Yeah.